If you have any questions during the webinar, can you please type them in, and in webinar jargon, raise your hand and send them through to us. The first part of our webinar today is to look at ESS BIZTOOLS. As many of you do not know how our products function, we have a series of tools. There are papers prepared to assist accountants to back their commercial advice to clients, to supplement the advice. There's about 500 papers targeted at small, medium enterprises that our clients are able to badge and send to their clients to support their professional advice. And then we have the products that have been developed. The business advisory services is in two components. The first one is assistance for an accountancy business to get ready to deliver business advisory services. And the second part is 15 product modules prepared ready for use in subjects such as debtors management, personal property securities register, which we're going to consider in detail shortly, and succession planning, chief financial officer services, buying a business, selling a business, business planning, and other activities. Business Plus is a newsletter we prepare every month bar January. It's available to our subscribers to send to their clients. They badge it with their names and details. They can edit the material if they wish. You can add material if you wish. Client mentoring and coaching is an education tool. One of the challenges facing accountants is to adequately educate clients on the type of services that your accountancy business supplies to clients. In survey after survey, small business operators have indicated that they're requiring additional services from an accountant or an advisor or someone, but some of them have not made the connection that their accountant, who they traditionally go to prepare an income tax return, can also offer them advice on succession planning, personal property securities register, cash flow management, debtors management, etc. So we believe the client mentoring and coaching modules assist in the education of the client. They're in predetermined series for you to be able to send them progressively to clients. There is a checklist for the client to record their thoughts on each of the articles so that you can follow up and hopefully sell additional services to the clients. Leadership modules, there are 8 modules on various components of leadership that have been prepared by a separate consultant, Peter McDougall, former colonel in the Australian Army. Peter runs a business called Leadership Academy. The material's there, prepared, ready for use. ESS client seminars or webinars, there's 34 pre-prepared seminars that you can use for marketing purposes. About half the seminars run for 1 hour. The others have got longer time periods that you can elect to present if you wish. There are hundreds of forms and other tools within the system to assist accountants to be delivering this very important product called business advisory services. There's tutorials that are available on YouTube, and we will supply you with a link to those. And then there's a product on a separate website, but quite integral to the overall product offerings, called ESS BizGrants, which assists with the identification of government grants for small, medium enterprises. The identification of government grants, we believe, is an integral part of offering a wider range of services. Most clients like the idea of getting 50% of the bill paid by a government department. Government departments are keen to expand the knowledge development for small, medium enterprises. So they're the products that fall within ESS BIZTOOLS. Everything that I've talked about there at this stage is part of our gold package. We have slightly less offerings in some of the other packages, which are called silver and bronze. But what I want to move into now is the theme for today, and that is the Personal Properties Securities Act and its associated Personal Property Securities Register. At ESS BIZTOOLS, we have developed a due diligence system to assist accountants and advisors to evaluate their clients' level of preparation. Now, some accountants are a bit concerned as to whether this is really accountants' work to worry about this problem of the Personal Property Securities Act. So why worry? Well, I think a good case in point is that millions of dollars have already been lost by businesses, both at the large end of town and small businesses, through ignorance of the operations of this legislation. I believe it's a time bomb for business. You don't know today whether you've done the right thing by registering on the register, but you might be very happy and your client might be extremely happy in 2 or 3 years' time. The converse of that also applies, of course, is that if something's gone wrong and there wasn't a registration and one of your clients has lost $1 million or $2 million or more, what's their reaction going to be? So what's the problem? Businesses are losing assets through ignorance of the law. I'm quite critical of this legislation. I'm quite amazed at how it become part of the statutes in Australia. I know New Zealand had it, but I don't know if that necessarily means that we've got to follow it. But undoubtedly, the authors of the legislation didn't realise that many businesses would not understand how the system worked. Why there was not a national education campaign similar to the GST when it was introduced, I don't know. But already in court cases and in costs for businesses, these are some of the businesses that have been affected. Motor vehicles and trailers, cleaning equipment and products, inventory, assets hired, leased or stored on someone else's property. This is a fairly common issue under this legislation. Businesses having no idea of the new rules that now apply to hiring and leasing. And what's on that screen there now are all businesses that have been affected by court case decisions. Machines owned by one company and hired to another company within the same group. You'd probably think that was fairly safe. This was a court case, QES. The holding company owned a significant investment in tractors and bulldozers and had hired these to a company within the same group. What someone obviously overlooked is that the trading entity had borrowed money from a bank. So there was a secured creditor. And for some reason, the asset owning entity did not make a registration on the Personal Property Securities Register. A liquidator was appointed because obviously there was a default, and the liquidator was given approval by the Queensland Supreme Court to be able to sell off those assets, which apparently were worth $2.2 million, for the benefit of the secured creditor. The other issue that's causing a lot of concern in the business community is preferential payments. I know of a situation in Melbourne of a cabinet maker who's been caught by a professional payment demand by a liquidator. The cabinet maker had made kitchen suites for a number of buildings in a housing display area. Unfortunately, the owner had a liquidator appointed, and The cabinet maker apparently had never done anything under the requirements of the Personal Property Securities Act, and therefore has been hit with a preferential payment demand because they've been receiving payments for 5 months. If you really want to know what's been happening in this legislation, talk to someone in the hiring and renting businesses. There's virtually no court cases on any of these cases because it's a pretty open and shut case. Registrations were not made. But I've heard of stories of a meeting in Melbourne a few months ago where at least a quarter of the audience, and with over 140 people at it, indicated that they had been caught out under this legislation for amounts ranging from $25,000 to $60,000. So some considerable costs have been incurred because of ignorance of the legislation. And just for the purpose of emphasis, I mention again this significant problem that's now emerging with preferential payments that have been occurring. This again basically gets back to renting and leasing or some sort of time payment arrangement with a customer. So what's the accountant's role in all of this? Well, I believe that accountants should be proactive about risk management. And surely this is one of the most important types of risk management that's come along for a long time. Some commentators believe that this whole legislation is the biggest change in commercial law in Australia in the last 200 years. That's virtually the whole time that the white settlement's been active in this country. In the first instance, though, it is necessary for small, medium enterprises, or indeed any business, because the problems have just not restricted to the small end of town. Some big businesses are caught, and there's some court cases going on at present that I assume it's best that I don't talk about in a broadcast like this, but we'll probably all be reading about it soon, where there's a lot of money involved. But businesses need to be encouraged to talk to legal advisors about terms of trade agreements and retention of title agreements. They need those, and they need them drafted after January 2012. Why? That's when this legislation started operating from. Yet there are thousands of small businesses got no idea of it. One of our clients that started using our system 4 weeks ago has told me that in 1 week they undertook 10 reviews, due diligence system reviews. One of the clients had some idea about the PPSA. The other one had heard something. Someone had written him a letter about it. But the other 8 had no idea. None of the 10 had been to see a solicitor. How many of your clients have got a regular arrangement with a commercial solicitor? When I was in public practice, I used to ask my clients every year who their solicitor was. And most of them shrugged their shoulders and said, oh, we really haven't got one. I had an accident 10 years ago and I saw one then, or I got divorced 15 years ago and I had one then. I don't think most of your clients have got this ready connection with a commercial solicitor. And therefore, unless someone's urging them to go and do something about this, are they going to do it? We conducted a webinar like this with Smith Inc. 4 or 5 weeks ago, and one of the participants was Darren Vardy, who's a director of SV Partners, a liquidator. And Darren made a comment at the end of the webinar, and I asked him if he'd put that in writing. And Darren did that. As an insolvency practitioner, quite often we are faced with suppliers who have retention of title clauses, RMALPA, in place, but are not aware of the changes in the security regime effective in January 2012. This lack of awareness amazes me and is predominant among small businesses. Unfortunately, the business owner generally finds out the hard way when faced with an insolvency practitioner who tells them that they no longer have the title and or ownership of goods. I wouldn't like to be sitting there in that meeting with a client with that sort of comment being made to them. So when's the time to act? Well, I believe it's now, literally today. Why? A transaction entered today could cause a problem at a future date through an insolvency event. We've got no idea when that future event might be. However, one of the real problems with this legislation is that you can't wait until there's a problem to go to the register to register that event. It has to be done now or within 20 days of today at the maximum. So let's look at these registration deadlines. If your client's supplying inventory to a customer, so a wholesaler supplying it to a retail store, then the registration needs to be made before the goods are actually delivered to the customer. If it's not inventory, it must be registered within 15 days of the customer, the grantor, obtaining possession. There's not much time in any of this. And if it's another security interest, such as the assignment of an intellectual property agreement or a loan agreement, it's got to be registered within 20 days of the date of the agreement. Now, I've had some accountants say to me recently, oh, we're busy and it's tax time. Well, it's always busy in an accountancy business. But they wanted to wait another 3 or 4 or 5 months sometime next year. But the real problem is if one of your clients is entering into arrangements with someone now that a decision could have been made to register, it's too late worrying about it next March. So that's the problem that we have. So what we're going to do now is take you to our website. So we're on the ESS BIZTOOLS website now. I'm just downloading to get our personal property securities register. I'll just open that up so you can read it. There's a lot of forms attached. We work through a procedure control form. You could place your logo on the procedure control form and your name and address so you can keep track of this, because you're going to be using this with one of your clients to conduct the review. You would download this into your hard drive so that you have a permanent record. And the procedure control form that we have for the PPSR due diligence system is very similar to the procedure control form we have for each of the other products within business advisory services and also within the system to help a firm get ready to deliver business advisory services. So we have links to other items. So if we have a very detailed paper within the system on the personal properties system. Don't forget, if you have any questions, can you please type them in the system, and in webinar jargon, raise your hand, and I'll be reviewing those near the end of the webinar. We're just waiting to download this paper. This is quite a large paper. Every paper we produce also comes with a set of PowerPoint slides, which the system skipped through that quick then. I didn't have time to just show you that. So this is a typical paper produced within the ESS BIZTOOLS system. In the space above the double lines here, a subscriber is able to brand it with their logo and name and address, etc. There's always a list of contents. And we'll just go through the content, so we go into the paper itself so you get some feel. There are linkages to the websites of the PPSR. There are linkages to other items within the paper. We are looking at pardon me. We're looking at the type of business transactions that can be caught under this legislation. Very extensive. I think one of the real problems with this legislation starts at the name of it. A lot of people look at it and say personal property, well, that's not my business assets, but it is. It's everything bar land and buildings. So it does include intellectual property, loans, service company arrangements. So there's a very detailed paper which goes for nearly 50 pages, which has got the whole system summarised. Talks about where it came from, the merge of 70 Acts of Parliament from around Australia. So that's part of the system which you would have. So we just go back to the control form now. There's a couple of other papers which give some additional information. Within the system we have a form, and this is similar to what's in all of the other business advisory services forms. There's a form to assist in the preparation of a quotation. So this is a quotation form, and we've gone through and tried to dissect the assignment as far as we can into the various components of it. Obviously some of these you might not be going to do, but it will give you a guide. Firms that are using this product already are telling me that some clients, they can undertake a review in 1 hour, some others longer, maybe 8 hours. Depends on the complexity of what's going on in the client's business and where they've got things located. So that's a form that assists in undertaking that review to determine a cost. There's also a proposal form, the quotation letter. There's also articles to assist the client to understand what this legislation's all about. So we have BAS forms. In our case, BAS means Business Advisory Services. We have a form which is the frequently asked personal property questions. So you could badge this form and send it to your clients, put their name on it. So it's an education process to help your clients understand how this system operates. There's some others like the 10 myths on the PPSA. And then we have the work checklist. Now this is where we're getting into the work. The checklists are there to guide you through the key components of what's going on. So the key areas that we believe you have to look at is, where is an item of property situated? Is it on your own premises, in which case there's virtually no issue. But if it's on leased premises or someone else's property or on consignment, there are potential problems in the event of an insolvency event occurring. And there's a lot more of these insolvency events or bankruptcy events or administration events than what you might normally think. So we have broken the stock into various components to really prompt the memory of the clients or the client staff who might not remember where some of these items are unless there's a specific question. And you can add others if you wish. And the real concern is what's going on if it's on someone else's property. We then need to review livestock and crops. We've got thoroughbred horses shown separately there because there's been an infamous court case in New Zealand whereby a stallion was seized worth $2 million with the support of the High Court of New Zealand. There's special treatment for farming businesses, especially if they've got crops on someone else's property or cattle or other livestock are gisted on someone else's property. There's a range of goods that can be caught up in this legislation. There are some benefits out of this legislation. It's not all one way. I might seem a little bit critical. I'm critical that there wasn't an education campaign. There's a concept of goods attached to other goods that is some benefit. If you've got a client that is supplying machinery that's going to be attached to someone else, to another product that's been made by someone else in a factory or a mine or somewhere, traditionally that was very difficult to have a Ramalpa clause attached to it because you would not be able to go back in and repossess it. But there is an attachment rule within this legislation which does give some protection, which you might want to look at. Mixed goods is obviously a big problem. Once grain's delivered to a silo, it's mixed with other grain. And then we go into artist works, looking at paintings, sculptures, etc. And so we keep on going. Plant and equipment. And we want to know whether it's been rented or it's on work sites, because all these activities have got slightly different interpretations. Leasing of plant and equipment. The periods that highlight that you should be undertaking some sort of protection if the asset is worth an amount of money that would financially embarrass the business if they lost it, is the leases up to 1 year automatically renewable, and the leases of more than 1 year, they can be specifically protected as leases. But the real problem is indefinite period leases and leases of up to 1 year. They can be the areas that cause the problems. And then there's problems, well, there's issues with motor vehicles. And at this stage, the legislation talks about 90 days. So instead of 1 year for motor vehicles, planes, boats, it's 90 days. Now, the House of Representatives has passed an amendment to make that 1 year, the same as other types of assets that might be leased or on hire. But it hasn't been passed by the Senate yet. And given the Senate's record of recent times, I don't know whether I'd be putting any money on when that might become law. So we're going through looking at motor vehicles, boats, aircraft, all fall under the serial numbers. Then we start looking at some other physical personal property. There could be some things that haven't been mentioned. You need to identify where they are. Debtors can come into this, especially if they've been assigned to someone. Financing. Licenses and trademarks fall under this legislation, especially if they've been assigned to someone else. Intellectual property. Similar comment if it's been assigned to another company. So it could be held by a holding company. It's been assigned to a trading company in your organisation who are then selling it. The real trap is if that trading organisation then borrows money, because then there's a secured creditor can come into play, and they have obviously got the right to appoint a liquidator. And you could have an insolvency event, and if there's no registration of the transaction between the holding company and the trading company, suddenly you could have a problem. Loans, the same thing applies, especially businesses need to be very careful about loans to associated entities. Statutory fishing rights, I haven't come across anyone that's got any dealings with them yet, but they're part of the legislation. That's why we've included it in the form. So that form keeps on going, looking at the various components. So if we just go back to the main procedure control form now to give you a feel of how this is working, it's then listed all of those items that we just looked at. The form asks questions about The retention of title clauses, have they been prepared or in particular reviewed since January 2012? There are forms in here for the business to consider what its financial exposure limit might be, because this is very important. This legislation is voluntary. It's fairly cheap voluntary. It costs you $8 to register. It's a very cheap premium. But businesses need to determine. So if the transaction's only going to be worth a couple of $1,000s, most people would probably say they don't need to register. But we have some forms in the system which will help the business to determine and the accountant to advise them as to what their financial exposure might be. So they would need to determine what their exposure might be, say, of 3 months trading with a customer, and then determine if they lost that amount, would they be financially embarrassed, in which case they probably should register. And the same thing applies to assets that they might have out on lease or hire purchase. If they are for time periods that they do not get any automatic protection, let me rephrase that. If they're not able to get protection under the legislation, they probably should be considering getting it. We have within the system special forms to assist with reviews of 17 businesses. They're listed on the screen there now: retail businesses, restaurants, hospitality, because they are slightly different in the way activities within those types of industries are treated, that you, in undertaking a due diligence review, you need to identify. So that's the review of the way the system works. I'm just trying to bring the forms back up here. We have a special offer at present that just while I'm getting the special offer. The special offer is a registration on the system, the Personal Property Securities Register, for $299. Thanks. Including GST. That's for 12 months utilisation of the Personal Property Securities Register due diligence system. We have been marketing this at $385, but we've decided to have a special promotion for the next 4 weeks to try to encourage accountancy firms all around Australia to be serious about undertaking these reviews. As I said earlier, there is a opportunity to earn professional fees from your clients for undertaking these reviews. Including in the kit is also included in the kit, I should say, is also a suggested letter that you would write to any client that wasn't wanting you to undertake a review. And our suggestion is that you should get that client to sign that letter, because unfortunately it could be some time in the future, it could even be 7 years before a issue arises and a client comes back to you with a complaint that you never told them about this problem or potential problem under this legislation. Incidentally, I'm told that in Victoria at present, 2 accounting firms are being sued by disgruntled clients who believe it was the accountant's responsibility to inform them of this legislation. It will be very interesting to see what the outcome of that is. So if you wish to take up our special offer, all you need to do is go to www.essbiztools.com.au, and on the home page we have a special log on for the Personal Property Securities Register due diligence system. Alternatively, you could subscribe to the total gold package for $2,970, including GST. This package includes the Personal Property Register due diligence system, but also includes our government grant program, ESS Biz Grants, together with our newsletter program, Business Plus, and all of the other material that I showed you when we first started this webinar today. If you wish to do that, you go to our web page and click on the pricing and sign up page to subscribe for the gold package. You can make monthly payments, which are available for the gold package, but for the Personal Property Securities Register due diligence system on its own, it's an upfront payment of $299, including GST. Now, I've had one question come through to me. Is the $8 for each asset you register? It's for each transaction that you register. It's a cost of $8. So obviously, once your client is determined what cover exposure they're prepared to absorb themselves, if you like, and that might be $10,000 for some businesses, it could be $100,000 for others. They then need to closely look at what the extra exposure might be to determine whether they're going to register. And it's not each individual invoice that you have to register. It's when you start supplying a client from a certain date that you are paying the $8 to basically register that client. Although you have to be very careful that your terms of trade agreement is wide enough if you change the type of transactions that your client has with one of their customers. For argument's sake, if the supplier is supplying coffee beans for a cafe or a retail outlet, that's a supply of inventory. But if they then decide to supply on a rental agreement a coffee making machine, and they believe it's of a value that would financially embarrass them if they weren't able to get it back, a check would have to be made to see that the terms of trade agreement were broad enough for that original registration. But in any case, if the original registration was for inventory, it probably would not be covering the registration for a coffee making machine, so that would require a separate registration being made. We're going to be running some further webinars on the PPSR. So we will be able to explore some of the other activities that you might look at in some aspects, such as being able to track the registrations that have been made against your clients on the register. The fun and games with this PPSR are really only just starting, I think. Now, I've been told there's some more questions here, so I'm just going to try and go back to get them. So just bear with me a moment, please. I'll just read these questions. A comment's been made by someone that there's an issue for accountants as they move into, particularly for practices moving into advisory space and additional revenue opportunities. One of the suggestions that I've heard is that, or comments that I've heard is that the two accountancy firms in Melbourne that have some pending action under this legislation were promoting themselves as being business advisors. I assume that's what the questioner is getting at. Whether that's the reason they've received legal advice, the small business, that their accountant could be liable, I don't know. But it's something that's been pointed out to me that both of the firms were promoting themselves accountants and business advisors. It might be something to be careful about. But I'd prefer you all to be far more proactive and to be adopting an attitude that this is risk management and that your clients deserve a joint approach by a commercial solicitor and you as their accountants to ensure that their systems are adequate to protect them from financial embarrassment. And the reason I believe that this is a role for accountants is that I don't know any solicitor, and I know hundreds of them, I've worked with hundreds of them over my career, that would actually go to a client's premises and sit down and work through the sort of checklist that we've produced to try to make sure that there's a full appreciation of where assets and stock and other plant and equipment, motor vehicles, what's going on with loans and intellectual property, etc. I really believe this is an accountant's role to assist the clients in this very important risk management area. So we don't seem to have any more questions. If you think of some questions later on, please send me a email, peter@essbiztools.com.au, or telephone me on 1-800-232-088. We look forward to hearing from you. The special offer runs for 4 weeks, and we will be running some special webinars for new subscribers to make sure that you fully appreciate all aspects of the product. And I'll just bring them back up to full size again. And don't forget that if you are interested in the total package, the gold package of ESS BizTools, which includes everything that we have in our system, together with supporting monthly webinars for subscribers and a support desk, please do not hesitate to contact us about a gold package subscription. In fact, you can go straight on the website and conclude the registration. So thank you very much for participating in this webinar today. Have a wonderful day. Goodbye.